So if you get the right to sue letter by the EEOC, they're not working on conciliation, or they've tried conciliation and of course it didn't work, you get the right to move forward and go to court. And you can certainly request a jury trial if you want to. Now, the judicial review occurs in the federal district courts if conciliation is not resolved, or if you got your right to sue letter and the EEOC is not moving, the case forward. You get what we call a de novo review, which basically means that the courts are going to look at this with clean eyes, regardless of whatever the EEOC said, and in their initial ruling, they are going to be looking at it with brand new eyes. It's important to know that the EEOC knows what they're talking about, and their litigation success is at 90%. So if they're taking up your case, you've got a fairly good chance of winning it. It doesn't mean that if they don't take up the case that you still can't win it, but it's a more difficult process, and it would need to be reviewed more deeply. So it is important to recognize that the courts will review that with fresh eyes. And so maybe there was something the EEOC missed, but you would have your own attorney, and then you would have to go to court to kind of move forward from there. There are some organizations that require mandatory arbitration. And mandatory arbitration is basically a private judge, and it is cheaper in many respects than going through a protracted legal case, and it is an alternative to the EEOC and any sort of general court processes. It's less expensive, it's quicker, there aren't any appeals because an arbitrator has a final rule and it's binding, and it's a fairly successful way of resolving these cases in a cheaper and easier way. The problem, of course, is that claimants may be forced to arbitrate, and they may not be comfortable with that, right? Sometimes you want to go to court because your chances of a larger reward, or perhaps being more likely to win your case, might occur if you're not going through arbitration. So that would be something to be aware of when you are going to work in an organization, whether or not they require mandatory arbitration, so that you're aware of that in advance. Traditional EEOC hostility was a barrier to arbitration, right? People didn't like going to arbitration. And so there was some challenges there. The policy changed under the Trump administration in 2019. It's hard to know right now what we can expect to see now after the election, whether things are going to change in that arena. You should be aware that Reconstruction Civil Rights Acts are still used here in the United States. Although the Civil Rights Act is pretty dominant, the Reconstruction Civil Rights Acts are still relevant, are still used in some areas. These were a series of laws that were passed after the end of the Civil War and during Reconstruction to protect the vast number of blacks and former black slaves who now were going to be out, in the workplace and out in society. And so it wanted to make sure it provided some minimal protections to individuals based on that. Of course, there were still issues of Jim Crow and other problems going on, but it is important to recognize that these Civil Rights Acts were active and present, and the Civil Rights Act of '64 was not the first law, but it sort of was more comprehensive than the Reconstruction Civil Rights Acts were. It was kind of hard to pass a lot of stuff, if you think about the context of the time, to pass, really deep and broad and expansive laws protecting blacks when people were still getting used to the idea that they were not going to be their slaves anymore. Some of the ways that these Civil Rights Acts from the Reconstruction era were similar is that they prohibited denial of civil rights. And how they were different is that there was direct court access and with fees and no agency process. Some current use went outside the limitations period. So it could be used if you miss your 180-day window. Or versus a government employer. It could be used in those contexts. So there's some limited use and available. So, there's always alternatives out there. And the big case is Patterson versus McLean Credit Union. And you should be looking at that for the purpose of understanding the law and its discussion in the textbook. Important note to be aware of that discrimination claims must be proved just as any other lawsuit is out there. An employee has to offer substantive evidence. That prima facie case has to be met. And of course, that's not where it ends, but it has to minimally meet that prima facie case to be able to go forward. And they have to offer evidence to support their claims. A great example is Ali versus Mount Sinai Hospital. Now, employers do really well when they have good documentation and they work very hard to treat their employees who are in those protected classes like they would any other employee. So when you are forthright, when you are transparent, when you are treating everybody fairly and equally, making sure everybody has got opportunities, equal access to opportunities, you're going to have less problem with discrimination charges. Treating your employees well, treating them fairly is the way to avoid problems with discrimination charges. There are a handful of management tips for this chapter. Number one, you should make sure that even your employees understand what Title VII is, what it requires, and who is eligible, right, to comply with it. So what is required, who it applies to, how the employee's actions can bring about liability for the employer. So if you as an employer may be aware of this, you as the HR professional in the organization may be aware of this, but the employee as a manager may engage in discriminatory behaviors. And so your managers, any employee, but certainly your managers, need to be aware of how this creates a liability for the organization. And the goal of educating people on Title VII protections and how to move through them is to minimize your liability. So you're not going to have problems, with lawsuits down the line if you've trained people well in understanding that. You need to make sure that people are aware of what actions will be looked into at a Title VII proceeding. So knowing what to expect, how they will be questioned, what information needs to be saved. And they should know that all employees have a right to a workplace free of illegal discrimination, and the employer will not allow Title VII violations. That's your job as HR professionals. That's your job as a manager in the organization, is to set the tone from the top about what the expectations are to ensure that discrimination doesn't occur.